Subcommittee will come to order. Well, good morning, everyone, and welcome to our subcommittee's first markup session of the year 2009. Today, we convene for the purpose of marking up H.R. 2994, the Satellite Home Viewer Reauthorization Act, which I'm pleased to have introduced along with the ranking Republican member of our subcommittee, the gentleman from Florida, Mr. Stearns. It is truly a bipartisan measure, and we have worked together as the provisions of our legislation were drafted. Certain provisions of the Communications and Copyright Acts expire at the end of this year, making reauthorization of the ability of satellite carriers to retransmit distant network signals must pass legislation. And that largely accounts for the reason that it is the first legislative item to come to markup in our subcommittee. At the subcommittee's hearings on this matter, I suggested that we proceed with this reauthorization in the most straightforward manner possible. And I'm pleased that we're following that course today and are avoiding in the bill collateral matters such as retransmission consent reform that are relevant not just to the satellite platform, but to all multi-channel video providers. The Satellite Home Viewer Act Reauthorization, or SHVRA, has these key provisions. It renews for 5 years the provision allowing carriers to deliver a distant network station to homes under specified circumstances, and that provision otherwise would expire at the end of this year. It reauthorizes the good faith negotiation requirements in the Communications Act, which also would expire at the end of this year. It provides needed clarification regarding the provision by satellite carriers of significantly viewed signals by stating that a significantly viewed signal may only be provided in high definition format if the satellite carrier is passing through all of the high definition programming of the corresponding local station in high definition format as well. It directs the Federal Communications Commission to adopt a predictive methodology for the reception of digital signals within 6 months in order to determine which households are eligible to receive distant network signals. And it makes a series of technical changes to the law to reflect the fact that after June the 12th, full-power television stations are no longer broadcasting analog signals. There are other matters that are not addressed in H.R. 2994 that are the subjects of ongoing discussions and that will continue between now and the time of our full committee markup. It's my hope that we will be able to resolve these matters over the coming weeks and include these resolutions in the full committee markup vehicle when that full committee markup occurs later this summer. The first of these matters was brought to us by the gentleman from Michigan, Mr. Stupak. His effort is to bring local satellite services to all 210 designated market areas nationwide. Today, DirecTV offers local service in about 150 of those 210 markets, and very soon, Dish Networks will be offering local service in 182 of the 210 markets. But even with that full complement of 182 markets being carried, that still leaves about 28 local markets without local-into-local service. I want to commend all of the stakeholders who have been participating in the discussions that are designed to achieve a way through a set of incentives to encourage one or both carriers to carry all 210 local markets. And I'm pleased to report this morning that we are very close to achieving agreement among broadcasters, satellite carriers, and other interested parties on this subject. I fully anticipate that an agreement will be reached on this matter prior to the time of our full committee markup. That would be a victory not only for broadcasters and satellite carriers, but also, and most importantly, for television consumers nationwide. Another matter that I look forward to resolving both here and in the House Judiciary Committee is ensuring that residents in short markets, these are markets that do not have a full complement of local affiliates carrying all of the major networks, can receive the programs of networks missing in their market from an adjacent designated market area. if the signals of those missing networks are not already being offered locally by a full-power broadcaster on one of its multicast streams. While satellite carriers can today import distant signals from any market, they are hindered in their desire to bring in adjacent market signals by the so-called grade B bleed problem that prevents them from offering distant signals to those households that can receive the signal of an out-of-market network affiliate over the air. And this grade B bleed problem persists in numerous markets across the nation. That problem can and should be resolved and usefully addressed, and I think we'll be in a position to do that as well by the time of the full committee markup. I want to express my appreciation to Mr. Stearns and to members on the Republican side of the aisle for their excellent coordination and cooperation with us, as over the last several months we have discussed the provisions of the Reauthorization of the Satellite Home Viewer Act as we undertook an oversight hearing and then a legislative hearing, and as we made preparations for the markup today. This has been a truly excellent bipartisan process, and I want to thank Mr. Stearns and all members for their outstanding cooperation. At this time, I'm pleased to recognize the gentleman from Florida, Mr. Stearns, for his opening statement.
Good morning, and thank you, Mr. Chairman. You are correct. This is a bipartisan bill, and we appreciate the opportunity to cooperate, and I think I urge all my colleagues to support our bill. The original satellite legislation in 1988 is credited with helping foster the incredibly competitive video marketplace that we have today, to the benefit of all consumers. Constituents and friends often tell me how much they love their satellite service. My sense is that that is the sentiment of most satellite subscribers, and that is why we have reauthorized the legislation each time it's come up for renewal, and why this reauthorization is just so important. The bill before us extends for another 5 years the authority of satellite operators to provide the signals of out-of-market stations to subscribers who cannot receive their local stations over the air. In addition, the bill makes clerical and substantive changes to the statute to reflect the end of analog broadcasting. In particular, it directs the FCC to update for digital broadcasting both the predictive model and the on-location testing rules for determining whether a subscriber is eligible for a distant signal. The bill also rectifies the FCC's implementation of the significantly viewed provisions. These provisions, added to the statute 5 years ago, allow a satellite operator to provide a subscriber in a local market with signals from a network affiliate in a nearby market if that nearby affiliate is watched over the air by a significant number of consumers in that local market. The statute prohibited a satellite operator, however, from carrying the significantly viewed affiliate in high-definition format if it didn't also carry the local affiliate of the same network in high-definition format. The FCC construed that provision to prohibit carriage of the significantly viewed affiliate in high definition at any moment of the day that the local station was not broadcasting in high definition. Because satellite operators find it infeasible to match the transmission formats of the two stations moment by moment, they usually choose not to carry the significantly viewed stations at all. To address that, the bill makes clear that a satellite operator may carry the significantly viewed affiliate in high definition when the local affiliate is not broadcasting in high definition, so long as the satellite operator does carry the local affiliate in high definition when it is available in that particular format. An issue that the bill does not address, my colleagues, but that may come up today is what to do about consumers who cannot receive programming they truly consider local, either because they are missing local affiliates from one or more networks in that market, or because they have been assigned to a designated market area outside that state. This issue is only worth considering if it is done in a way that truly respects the rights of the broadcasters that would be imported, the owners of the programming, and the satellite operate to negotiate the terms of such carriage. We must clear existing regulatory obstacles rather than create a whole new set of rules, As I've already mentioned, the video market is robustly competitive. In that environment, there should be less interference in the market, not more. At the last hearing on satellite legislation, some raised an interest in letting satellite providers carry broadcast stations to viewers in adjacent markets, that is, outside of the DMA, even when there are local affiliates in the DMA. I agree with leaving it out of the bill at this time. While I can understand the goal of delivering more in-state news throughout a state, I'm still not convinced we have to legislate in this area to reach that goal. Going down that road poses significant harm to consumers, broadcasters, and content creators. Whatever we do, my colleagues, we should ensure that the satellite operator, the out-of-market station, and the owners of the content are allowed to freely negotiate. That is the best way to ensure consumers get as much desirable content as possible at the lowest rates. Anything else simply protects one company at the expense of another without really helping consumers. And at its core, this legislation should be about the consumers. I would conclude, Mr. Chairman, by just making a little personal announcement. Many of you saw Amy Bender, who is our counsel on the Republican side. She had the birth of her daughter recently, Megan Claire Bender Perkins. She was born this past Tuesday. And mother and baby are doing very well. And also I'd like to congratulate our other Republican counsel, Neil Freed, on his engagement and pending wedding this fall. So congratulations to both Amy and Neil.
Would the gentleman yield just for a...
I'd be glad to yield.
I would just note that the parents are meeting for the first time this afternoon in New York at 5, and it's important that we finish this so he can catch a 1 o'clock train up to New York.
Mr. Upton, I appreciate you encouraging promptness here. That's extraordinarily helpful. The gentlelady from California, Ms. Matsui, is recognized for 3 minutes. And the gentlelady waives her opening statement. The gentleman from Pennsylvania, Mr. Doyle, is recognized, and Mr. Doyle also waives. The gentleman from Ohio, Mr. Space, is recognized, and he also waives. We are cooperating as well as we can on this side. Thank you. At this time, I would like to recognize the ranking Republican member of our full committee, the gentleman from Texas, Mr. Barton, for 5 minutes.
Well, thank you, Mr. Chairman. I'll submit my formal statement for the record. I'm just glad to say we're having a boring reauthorization hearing on the Satellite Television Reauthorization Act instead of a contentious, controversial hearing about the failure of the DTV transition. I think we all know that happened several weeks ago, and nothing happened. It just went seamless. I still have yet to buy my coupons, so I have some TVs that don't work, but I'm going to talk to my congressman about that and tell him to get off the dime. On this act, Mr. Chairman, we've worked in a bipartisan fashion as we get ready to reauthorize. I know there are a few issues of local interest to several members, but we think that this is going to be a pretty straightforward reauthorization, and we look forward to working with the majority to make that happen. With that, I yield back.
Thank you very much, Mr. Barton. The gentleman from Michigan, Mr. Upton, is recognized for 3 minutes.
I will defer.
Thank you, Mr. Upton. The gentleman from Illinois, Mr. Shimkus, is recognized for 3 minutes.
Only because Michael Doyle did not say anything on telecommunications, I will also defer.
Thank you, Mr. Shimkus.
I'm shocked.
This is just excellent cooperation. The gentleman from Nebraska, Mr. Terry, is recognized for 3 minutes. Thank you, Mr. Terry. The gentleman from Missouri, Mr. Blunt, is recognized for 3 minutes.
Mr. Chairman, I have a statement for the record only, and I'm just glad you're having this hearing and hope that we are able to move forward with the markup as it's intended.
Thank you very much, Mr. Blunt. The gentleman from Oregon, Mr. Walden, is recognized for 3 minutes, and he waives. And the gentleman from California, Mr. Vrdanovich, for 3 minutes. Thank you very much, Mr. Vrdanovich. Do we have anyone else? Oh, the gentlelady from Tennessee, Ms. Blackburn. I did not see you on the front row.
I am the only one taking the front row seat. And in the spirit of cooperation, I will waive and then offer my amendment in the spirit of that a little bit later. And in the spirit of cooperation, I will withdraw
I can't thank you enough. That concludes opening statements from committee members. And at this time, we will declare the bill open for amendment at any point, and I am pleased to call up H.R. 2994, the Satellite Home Viewer Reauthorization Act. It is without objection open for amendment at any point, and I have a manager's amendment at the desk. The clerk will report the amendment.
Amendment to H.R. 2994, offered by Mr. Boucher of Virginia.
And without objection, further reading of the amendment is waived, and I will recognize myself for 5 minutes to explain the amendment. This manager's amendment is very straightforward. It makes one technical change and has two provisions further defining the digital over-the-air reception predictive model that we are directing the Federal Communications Commission to develop. The first provision requires that the Commission rely on the current Longley-Rice model, which has worked very well for predicting the reception of analog signals, and this direction would require the Commission to continue utilizing that Longley-Rice predictive model and simply update it to predict the reception of digital signals. The second provision clarifies that the model should predict the ability of homes to receive the local over-the-air signal through the use of a conventional stationary rooftop antenna. That has been the test that we have had in the law since the first Satellite Home Viewer Act was passed in 1998, and we continue that standard with the manager's amendment. That is all that the amendment does. I hope it will be the privilege of the committee to accept it. And I would ask at this time if there are any other members who have comments or seek recognition on the amendment. The gentleman from Florida, Mr. Stearns.
Thank you, Mr. Chairman. And I would just say to my colleagues, basically his manager's amendment is providing a status quo. I think there was, in the bill itself, there was a change, and the chairman is going back to the status quo, which, frankly, I have no problem with at this time. I think we should go along and accept this in the subcommittee. I think when it gets to full committee with Mr. Barton and his counsel, they should have an opportunity to look at this manager's amendment. Basically, it would reinsert a statutory provision forcing the FCC to assume all consumers have a large outdoor antenna on their roof. It's not specified whether it's 20 or 30 feet. We know that many consumers, if not most, do not have such a rooftop antenna. This has certainly been highlighted in the recent digital transition. Assuming they don't have an antenna that makes it appear that they don't get the adequate signal over the air, when both we and they know that many of them don't. This disqualifies them from receiving a distant network signal over the satellite. As a result, many of them do not get network programming at all because without the rooftop antenna, they can't get a signal over the air. So the implications of this is still, I don't think, a major concern, but I want to leave that option open in case members, either on both sides, when they look at this, they might hear from constituents about, what this means in terms of their satellite reception. We can look at it more carefully in the full committee, but Mr. Chairman, I certainly will support the manager's amendment as you've offered it.
Thank you, Mr. Stearns. Would you yield to me for just a moment?
Glad to yield.
I appreciate the gentleman's comments, and I'll have to say that from time to time over the last 2 decades, I have had many of the same concerns that the gentleman has expressed. This is the model that we've used, and for purposes of today's markup, I think it's appropriate that we announce our intention to continue it. But in my view, just as in Mr. Stearns' view, that is a decision subject to further conversation, and we would welcome the views of others who might have an interest in this subject between now and the full committee markup, and I thank the gentleman for raising that point and for yielding to me.
Yeah, I yield back.
Is there further comment on the manager's amendment? Does any other member seek recognition? If not, the question occurs on the amendment. Those in favor will say aye. Aye. Those opposed, no. The ayes have it, and the amendment is agreed to. Do other members seek recognition for purposes of offering amendments? The gentlelady from Tennessee, Ms. Blackburn.
Thank you, Mr. Chairman. I do have an amendment at the desk.
The clerk will report the amendment.
Amendment to H.R. 2994, offered by Mrs. Blackburn of Tennessee. At the end of the bill, add the following new section.
Without objection, further reading of the amendment is considered as read, and the gentlelady is recognized for 5 minutes in support of her amendment.
Thank you, Mr. Chairman. I do appreciate that. I am wanting to bring to everyone's attention a tragic yet critically important event that informs my deliberation on a great many policy issues that come before this committee. On February 5th, Super Tuesday, last year, we had the Super Tuesday tornadoes in West Tennessee. It was devastating. It left 33 people dead and over 150 were seriously injured. We had entire communities that were in tatters, and some of those communities still are. Through the dedicated work of state and federal disaster response coordination, many lives were spared. We had property that was protected, and yet government agencies were not alone in preparing West Tennessee. Local broadcasters played a critical role by providing communities up-to-the-minute information so that families could take the proper precautions in advance of the gathering storm. Without the service local broadcasters provided, I have no doubt the storm's impact would have been much more devastating. This was not the first, and it will not be the last tornado that threatens West Tennessee. Yet in the wake of the successful transition to an all-digital broadcast signal, many of my constituents find themselves out of range, out of luck, and unable to receive an over-the-air signal of any kind. In most urban and suburban communities, this is not a problem. Cable and satellite providers can supplement a weak or non-existent over-the-air signal and provide communities the local programming they need. But in the rural areas like Hardin, Hardeman, and Chester County in the 7th District of Tennessee, these options are not always available. Cable service is often unavailable outside the county seat, and in the Jackson DMA, satellite providers do not carry local-into-local programming. Why? The Jackson DMA, which includes just over 98,000 television households, is a short market, served by only 2 of 4 major broadcast network affiliates. Since the Jackson DMA lacks a full complement of major broadcast network affiliates to serve the community, both major satellite providers elect not to deliver local-into-local programming, deeming the service either too expensive or undesirable for consumers to merit the cost of delivery. Further, though the current law allows for distant signal retransmission when a subscriber is deemed unserved, some subscribers in short markets are deemed served. As a result, they are ineligible to receive the out-of-market signal from the satellite provider. This is known as signal bleed. Constituents in these rural areas are therefore left with no option to receive broadcast programming. This is not a simply inconvenient problem. In areas throughout the nation, and like in West Tennessee, this is a public safety issue. The amendment before you reflects a common sense solution to solve the signal bleed and the short market problem. It provides a free market mandate-free incentive for satellite providers to carry those affiliates that are in the local market. The amendment accomplishes this goal by allowing satellite providers to retransmit missing network signals from an adjacent market to subscribers who reside in the short market and are within the over-the-air signal bleed. What it does not do is this. The amendment does not require satellite providers to provide the service, does not impact the retransmission consent rights, does not affect a local broadcaster's network non-duplication, syndicated exclusivity, or sports blackout rights. And just as important, the amendment is 100% silent to whether a compulsory license applies or whether the license shall be freely negotiated. This is a decision that will be dealt with before the Judiciary Committee and not in Energy and Commerce, and I understand that. If adopted, the amendment would provide a free market incentive for satellite providers to solve the short market problem while protecting contractual rights and intellectual property value for our local broadcast affiliates. Recognizing all of that, I'm going to withdraw this amendment this morning, as I said earlier, Mr. Chairman, in the spirit of full cooperation. I recognize that stakeholders, including broadcasters and members of the creative community, have raised concerns, and we need to work through all of this. The NAB has pledged to work with me, the chairman, and all of our impacted committee members to make appropriate changes and ultimately solve the short market problem. And, Mr. Chairman, if you'd indulge me in a brief colloquy, I'd like to take this opportunity to seek your help in bringing all parties together. I know you're committed to solving the problem, and if that is appropriate at this time, I'd like to yield to you for comment.
Thank you very much, Ms. Blackburn. I want to express my appreciation to you for bringing this matter before the committee. I also made reference to this need in my opening statement, and I think we absolutely must fix this short market gap. The grade B bleed, as you have so well described in your statement, is the principal impediment to doing that, and the correction of the grade B bleed barrier actually is not within our jurisdiction. It's within the jurisdiction of the House Judiciary Committee, as you've also noted in your statement. Nevertheless, I think this is the committee where we can assemble all of the interested parties. We can conduct useful negotiations and discussions with the relevant stakeholders, and your urging that that take place is an urging that I will second, and I look forward to working with you and interested parties and all members who have a concern about this issue as we continue to address it. I also appreciate your willingness to withdraw the amendment for today's purposes, and we in fact will continue these conversations, and I thank you for yielding.
Thank you, Mr. Chairman. I appreciate your work on this. It is a public safety issue for some of my counties, and I thank you for your consideration and yield back my time.
Thank you very much. Without objection, the gentlelady's amendment is withdrawn. Do other members seek recognition for purposes of offering amendments? Any members on the Democratic side? Other members on the Republican side? The gentleman from Georgia, Mr. Deal.
Thank you, Mr. Chairman. I have an amendment at the desk, but I'm not going to offer it. I would ask the chairman if he would engage in a colloquy with me.
I'd be happy to respond. If the gentleman will yield to me.
If I may precede that, I would like to lay out the issue that I...
Let me recognize the gentleman for purposes of striking the last word. And the gentleman has asked for a colloquy, and let me ask if the gentleman will yield to me for that purpose.
I certainly will.
I'd be happy to engage the gentleman.
Thank you very much. Mr. Chairman, as you know, under the current designated market area system, in 98 DMAs across the country, satellite and cable subscribers cannot get their in-state programming. These are the so-called orphan areas that can't get in-state broadcast stations for news, sports, public affairs programming simply because they're assigned to a DMA whose broadcast signals originate from a city in another state. Many of the viewers in this county, some of whom are my constituents, would like to view their in-state television and are willing to pay to do so, but cannot under the current DMA system. The amendment that I have at the desk is a little different approach than what has been discussed on this issue in the past. It is designed to allow all the stakeholders to continue the discussion of how to provide in-state programming to consumers who are assigned to these out-of-state markets. It applies only to satellite, although personally I would like this to apply to all MVPDs for purposes of parity. The amendment does not make carriage of the adjacent market signal mandatory for either the satellite operator or the broadcaster. It would allow broadcasters to negotiate retransmission consent agreements, and while the network non-duplication rules do not currently apply to most satellite programming, the amendment does not prohibit the FCC from applying network non-duplication rules in these circumstances. The amendment also does not force carriage of the content with a compulsory license. This is a copyright issue within the jurisdiction of the Judiciary Committee, of course, of which you serve as well. It is my hope that we can, before we go to full committee, sit down together along with other members on both sides of the aisle who have expressed concern about this issue and see if there is any resolution that we can come to before we get to the markup in the full committee. And I would just simply ask the chairman if he would be willing to engage in that discussion.
Well, I thank the gentleman very much for those comments and for bringing the issue before us. This is a matter that was raised in both of our previous hearings on the Satellite Home Viewer Act. There is interest in accomplishing the same goal the gentleman has identified by members on the Democratic side also. And it's my hope that through a process of consultation we can at the proper time arrive at a consensus-based solution to this problem. There are areas around the country where fairly small populations in one state are receiving their television programming from the balance of the DMA in which they're situated, which is the majority part of the DMA, and that's located in another state. And so the local television programming that these individuals receive actually originates in the neighboring state. And many people in that situation think that that news and local programming is less relevant to them than would be the news and local programming that originates in the adjacent market in the state in which they live. And that situation pertains in a variety of markets across the United States. It is my hope that we can reach a solution. And some of the issues that have been raised in connection with reaching that solution would be the need to respect the retransmission consent rights of broadcasters and not in some way diminish their market opportunities to obtain retransmission consent agreements because of adjacent market imports. Having perhaps some kind of percentage cap on what the size of this orphan market that would be subject to whatever repair is made would happen to be. Having respect for the complementarity of high-definition carriage so that you would not have a circumstance where the in-state signal, the NDMA signal was being carried in standard def and the imported signal was high def. That would create something of a competitive disadvantage. And then there is the much more thorny issue of whether or not to respect the syndicated exclusivity and non-duplication, network non-duplication rights. So as that list suggests, resolving this is perhaps not an easy matter. Now, all of that said, I would very much like to see it resolved, just as I know the gentleman from Georgia would, and I will be happy to continue discussions with him and other interested members of the subcommittee and interested external parties as we seek to get to that goal.
I thank the chairman very much. He certainly has an understanding of the complexity of the issue, but he also, I'm sure, has an understanding of the importance of this to those constituents, and there are many of them all across this country who fit into that category. I thank you for that, and with that, Mr. Chairman, I would yield back my time.
Thank you very much, Mr. Deal, and without objection, well, the gentleman didn't offer the amendment, so it is not pending. Are other members seeking recognition for the purpose of offering amendments? I just received a note saying that Mr. Stupak, who very much wanted to be here this morning, had to depart to attend a funeral in his state, and he's apparently at the airport and seeking to get back to this markup. And due to the extraordinary cooperation of members, we are nearing the end point of this markup. So let me take the opportunity, and I'll recognize myself to strike the last word for this purpose, of saying that Mr. Stupak brought before us the challenge of finding a way to make sure that all 210 designated market areas across the United States are receiving what we call local-into-local television service, where the local television stations are uplinked to the satellite and then retransmitted back into the market of their origination. And there will be about 28 markets after Dish Networks completes its intended range of local market carriage. There will still be about 28 markets across the country not served. And we are conducting, at Mr. Stupak's urging and with his encouragement, negotiations among the interested parties, primarily broadcasters and satellite carriers, to find a way that through a set of appropriate incentives we can achieve the carriage of all 210 markets. As I said earlier, these negotiations are going very well, and we were within perhaps a day or 2 days of, I think, reaching agreement on that appropriate set of incentives that would assure the carriage of all 210 markets. But because of the impending upcoming recess and the need to move this bill forward, we held the subcommittee markup as originally scheduled. But given the pace of these negotiations, I think we're going to be in a position prior to full committee markup to have this agreement in place. So Mr. Stupak asked that I make some comments about the 210 issue. I think the news on this is pretty good, and I want to simply encourage the parties that have been involved in these conversations to perhaps redouble their efforts, and maybe the good news awaiting us when we return from the upcoming recess will be that this challenge is resolved and we'll be ready to assure that all 210 markets are covered when the full committee markup occurs. Let me ask again if there are other members seeking recognition for purposes of offering amendments. I do not see any hands raised. And so, at this point, I will say that the question occurs upon the amendment. I'm sorry, the question occurs upon, excuse me. At this point, I move that the Subcommittee on Communications Technology and the Internet forward H.R. 2994 as amended to the full committee with the recommendation that the bill pass. Those in favor will say aye. Aye. Those opposed, no. The ayes have it, and the bill is favorably reported by the subcommittee to the full committee. I ask unanimous consent that staff be authorized to make technical and conforming corrections without objection. So ordered. And with thanks to all of the members, this markup stands adjourned.